Craig Becker serves as Associate General Counsel to the AFL-CIO and the SEIU Union. He served as a partner at Kirshner, Weinberg, and Dempsey, and taught labor and employment law at UCLA, the University of Chicago, and Georgetown Law Schools. He has written numerous articles on labor and employment law and recently represented Evelyn Koch before the Supreme Court. He is a graduate of Yale College and Yale Law School.
Chairwoman Woolsey, Ranking Member Wilson, other members of the committee, thank you for giving me the opportunity to testify here today. When I appeared before the Supreme Court on behalf of Ms. Koch, many of the justices expressed concerns similar to Member Wilson about the cost of protecting home care workers by the Fair Labor Standards Act. I would have liked at that time to turn and point to my client sitting in the audience in a wheelchair being taken care of by her elderly son so that the justices could have understood the human cost of excluding home care workers from these basic minimum protections. The etiquette of the Supreme Court prevented me from doing that, so I was very happy when you invited me here to testify today. In my very brief time, I'd like to make 4 points. First, when Congress extended the Fair Labor Standards Act to most domestic workers in 1974, it excluded babysitters and employees who provide, quote, companionship services to individuals who, because of age or infirmity, are unable to care for themselves. But it did not intend to open up the gaping hole in the Fair Labor Standards Act which exists today. What Congress intended in 1974 was to exempt babysitters, and we all understand what babysitters are, and something akin to babysitters. That is what the Chief Senate sponsor called, quote, elder sitters. That is, in 1974, Congress understood companionship services to be services provided in a casual neighbor-to-neighbor relationship. Congress explicitly said it did not intend to exempt regular breadwinners, people responsible for their family's support. Since 1974, however, this industry has changed dramatically, not only because the number of home care workers has exploded, but because the nature of their work and their employment relationship has changed. These are no longer neighbors employed on a casual basis, but employees largely employed by third-party agencies, most of whom are for-profit. The exemption is now being applied far beyond what Congress intended. Congress surely did not intend to exempt what is today the fastest-growing occupation in the country. Second, there is nothing about what home care workers do today which justifies treating them as second-class citizens, exempt from our nation's most basic employment standards. This work they perform is no less demanding than a file clerk, a nursing home worker, or any of the other categories of employees who are protected by the Fair Labor Standards Act. Despite the misleading term in the statute, companionship services, these workers perform a range of personal and domestic tasks which have already been described. They bathe, feed, and move clients. They cook and clean. They assist with medication and using the toilet. In fact, they do almost everything except sit and act as a companion. And they perform these essential tasks usually for 2, 3, and 4 clients on a single day, and none of them are typically neighbors. Their work is emotionally and physically demanding, as evidenced by the fact that the rate of injury, on-the-job injury for home care workers is far above the national average. I ask you, what possible justification could there be for not giving these workers the right to receive the minimum wage and additional pay for overtime enjoyed by almost every other employee in this country? There is simply none. Third, the exemption is not only unsound employment policy, it's unsound long-term care policy as well. There's a growing shortage of home care workers due to the aging population and most consumers' preference to receive care at home as opposed to in an institution. This shortage is projected to increase dramatically. Low wages obviously contribute to this shortage, as well as to high turnover, which impairs the quality of care. And that's why advocates for consumers, for example, the AARP, took Ms. Koch's side in the Supreme Court because they understand Those who advocate for consumers understand that the greatest threat to the quality and availability of services is not the extension of the Fair Labor Standards Act, but the failure to extend the Fair Labor Standards Act, which will exacerbate the shortage of home care workers. Finally, opponents of the bill will tell you that it will increase costs and lead to reductions in services. But as the chairwoman has already mentioned, many states, including my home state of Illinois, already protect home care workers with their state wage and hour laws, and the quality of care in those states has not been diminished. Only a small percentage of clients receive more than 40 hours of care per week. Therefore, the fiscal impact will be modest, as projected by the Clinton Labor Department. More importantly, there is simply no moral or policy justification for requiring the individuals who provide these essential services to bear that cost, whatever it is. There's no justification for asking these workers to bear the cost of our society's unwillingness to devote sufficient resources to long-term care. It will only exacerbate the shortage of workers and decrease the quality of care. I urge the members of this subcommittee to recommend adoption of the Fair Home Health Care Act. Thank you.